Hello everyone, I'm Ankit and you're watching StudyIQ IAS English. In our today's video, we'll try to understand why is Article 22 given in Part 3 of the Indian Constitution, that is fundamental rights, in news recently. Now the notes that I will be using in this session, in case if you want to download them, you can go to a particular Telegram channel called as ETS Live. And while you're in this channel downloading the notes, please do not forget to subscribe to the channel also. Okay, so let us start by understanding why have we taken up Article 22 for our today's discussion. Now, in a landmark ruling of the Supreme Court, which came as latest as last week, the Supreme Court highlighted that police, before they make an arrest, they have to ensure to communicate the grounds of arrest to the person who has been arrested. And this should be done in form of writing and in a language that is understandable by the person who has been arrested. Similarly, the Supreme Court also stated that this communication of the grounds of arrest should be done in a reasonable time frame, and the latest by which you can inform that person on the grounds of arrest should not be late of at least 2 hours before that person is scheduled to be produced in front of a judicial magistrate so as to allow for extension of his or her custody. So these are the ground rules that the Supreme Court laid down in its recent ruling. Now, Supreme Court also made one thing clear, that this key procedural safeguard provided under Article 22 of the Indian Constitution is applicable for arrests made under all offences, which includes normal criminal and quasi-criminal cases, and also includes stringent and special laws that have been enacted to bring what? To bring preventive detention into play. That is laws like Prevention of Money Laundering Act, laws like the UAPA Act or Unlawful Activities Prevention Act of 1967. So all the offences, be it preventive detention under special laws and criminal laws, these key procedural safeguards that I've highlighted would be applicable to all arrestees. Understood? So this is what the Supreme Court highlighted. Now just look at this 2023 question. Look at the second statement. The Constitution of India exempts the states from providing legal counsel to a person who has been held under preventive detention. So this shows you that preventive detention is an important part of polity that is given in Part 3 of the Indian Constitution. And from exams perspective, particularly UPSC Prelim, this topic also is very important. So before solving this question, let us understand what is this Article 22 all about, and then we'll try to solve this question before trying to attempt a practice question before ending this discussion, okay? So let us start by understanding more of this context. Now, Supreme Court in this ruling, which I highlighted recently in this particular slide, the Supreme Court also stated that mere communication of the grounds of arrest in a language which is not understood by the person who has been arrested does not ensure fulfillment of Article 22 of the Indian Constitution. Article 22, as we'll learn in our today's video, provides certain protections to persons who have been arrested or are under preventive detention. And a failure by law enforcement authorities to supply such grounds to the person who have been arrested renders the constitutional safeguards imaginatively. Similarly, it infringes on the personal life and liberty of a person, which is guaranteed to them under Part 3 of the Indian Constitution, under Article 21, that is right to life, and under Article 22, that gives you certain rights of protection in cases of arrest in the Indian Constitution. So that is why we have picked up Article 22 for today's discussion, which is central to this particular instance or the judgment that was given by the Supreme Court of India. Now, what is Article 22 of the Indian Constitution? On the first hand, as I told you, it is a part of fundamental rights given in Part 3 of the Indian Constitution, and it provides protections to individuals in cases of arrest and in cases of detention. So naturally, this article can be divided into two parts for simplicity of our today's discussion. First part, it deals with cases of ordinary criminal laws, and second part, it deals with special cases that allows for preventive detention of people in India, which includes acts like National Security Act, acts like Prevention of Money Laundering Act, acts like Unlawful Activities Prevention Act. So first, let us try to understand the normal cases in which protections are provided to people who have arrested. Then we'll cover the second instance where certain protections are extended to people who are under preventive detention. Now, first, let us talk about the first part of Article 22, specifically Article 22.1 and Article 22.2. Now, this piece of legislation, that is the provision given in the Indian Constitution, it gives certain rights to people who have been arrested under normal criminal laws. The first right that it gives to the person is right to be informed of grounds of arrest, and it states that no person can be arrested without being told why they are being arrested. And you know why this ground is provided? So that this gives the person the opportunity to contest or make representation in the court challenging this arrest in the first place, right? So this was the first reason why this right has been provided to any person in India. Now the second right that it gives is right to be consulted and be defended by a lawyer of one's choice. So it means that in case if you're arrested in under any criminal law in India, then you have the right to judicial recourse. And how would you ensure judicial recourse? By first of all consulting with a lawyer, hiring the lawyer so that they can get you the necessary hearing in the court. And this also says of one's choice. So suppose if the person is poor, is unable to hire a lawyer, then it is the responsibility of a state to provide a lawyer to the person who has been arrested. The third right this article provides is that you have the right to be produced before a judicial magistrate, and this should be done within 24 hours of the arrest. And this does not include the time it takes to commute to the court of law, right? So this is not included in this particular 24 hours. The fourth right, this first part of Article 22, it provides you right not to be detained beyond 24 hours without adequate authorization given by judicial authorities. So these are the four rights that is provided in the first part of Article 22. I told you first part of Article 22, it is applicable to ordinary criminal laws, and it provides certain rights to people who have been arrested. And the primary reason why these rights are provided so that you can contest these arrest decision in the court of law by getting the grounds on which you have been arrested, by hiring a lawyer, consulting a legal professional, and you're not supposed to be kept in a custody beyond 24 hours without adequate judicial authorization, right? So these are the first part of Article 22. Now, naturally, these parts are not available to certain sections of people. So, who are these sections of people? First of all, it is not applicable to enemy alien. Enemy alien is a non-citizen who hails from enemy state of India. And any person who has been arrested under any preventive detention law, they are also not eligible for these kind of rights provided under first part of Article 22. Now, Supreme Court has also ruled that arrest and detention in the first part of Article 22 does not cover arrest which are made under civil cases or arrest in cases of failure of paying income taxes or even deportation of an alien to another country. So these rights are not provided to these kind of people, and they only apply to an act of criminal or quasi-criminal cases, not where public interest are in harm, right? So these are the grounds on which the first part of Article 22 is not applicable. Now let us move to the second part of Article 22, that is Article 22(3) till Article 22(7). Now this second part of Article 22, it provides grants to protections to certain persons who have been arrested or detained under any law which provides for preventive detention. So this protection, as against the first part of Article 22, is available to both citizens as well as non-citizens. Whereas the first part of Article 22, that is Article 22(1) and Article 22(2) was only applicable of citizens, and it was not applicable on enemy aliens. So this is what you'll have to remember, which is different from the first part of Article 22. Now let us understand what are the rights provided to people so as to protect them if they are arrested or detained under any law providing for preventive detention. First of all, the protections that are provided to them, they include detention of a person. It cannot exceed the time period of 3 months until and unless an advisory board reports sufficient cause for continuation of detention. Now, you have to remember, every government creates an advisory board, and this advisory board must be headed by a judge of High Court. And this advisory board would actually review your detention before the expiry of 3-month period. And only after they give the consent, only after they agree to the fact that continuing of detention is in broader public interest, in broader national interest, then only your detention would continue beyond the period of 3 months. Similarly, here also the ground of detention needs to be communicated to the person who has been under detention. But there are certain exemptions. This exemption allows that if there are facts making themselves public would harm the public interest, then in that case you can't or you should not communicate the grounds of detention. So normally grounds of detention needs to be communicated, but in case those grounds of detention harms public interest in general, then they should not be communicated, right? And the detainee should be provided an opportunity to make a representation against this detention order. So here also judicial recourse is available to the person who has been held under detention, that they are afforded a chance, an opportunity to make a representation seeking a review of this detention order. So these are the protections provided in the second part of Article 22. I told you these are applicable only to persons who have been arrested or detained under preventive detention law. Now, this second part of Article 22 allows Parliament to bring a legislation dealing or regulating with preventive detention. And in this legislation, Parliament has some powers. What are the powers Parliament have? Let's find out. Now, the first power that Parliament has, that it can lay down certain circumstances and the classes of cases in which the detention provided in different laws which will be enacted by Parliament can be for more than 3 months under preventive detention law, and this should be, or this can be done even without obtaining the necessary opinion of advisory board. So this allows Parliament to bring a separate detention law which provides for detention of more than 3 months without even trying to seek the permission of advisory board. And Parliament can also bring a law which would provide maximum period for which a person can be detained in any case for that matter. And it also provides the grounds or procedures that should be followed by the advisory board when they are making an inquiry or when they are reviewing the preventive detention instances. So this is what Parliament can do through what? By a law passed by Parliament. Now, this brings my attention to the division of legislative power. Now, theoretically, both Parliament and state legislature can enact laws which can provide for preventive detention. But naturally, their sphere of legislation would be on different areas. So, let us understand this. First of all, let us try to understand what the powers Parliament have, or under which areas can it bring legislation dealing with preventive detention. Now, what you have to understand, Parliament has exclusive authority to make laws on preventive detention for reasons which are connected with defense of India, with foreign affairs of India, with other countries, and with respect to security of the entire nation. Whereas state legislature and Parliament both, they have concurrent powers in some areas. So what are these areas? Now let us understand. Now, Parliament as well as state legislatures both have the power to make a law on preventive detention for reasons which are connected to security of a state, maintenance of public order, and maintenance of supplies and services which are essential to the community. So I told you once again, let me repeat it. Parliament has exclusive power to deal with matters of preventive detention when the cases are concerned with respect to security of the entire nation, defense of India, as well as foreign affairs with India and other countries. Whereas both Parliament and state legislature, they have concurrent authority that both of them can make laws when it deals with preventive detention for security of a state, or for maintenance of public order, or for maintenance of supply of essential goods and services, right? So this is what the division of legislative power is as far as Article 22 is concerned. Now, before we move to PYQ that I showed you at the beginning of our today's discussion, before we solve them, I have something very important I needed to communicate to you. Now, Article 22 is a part of fundamental rights of the Constitution, as I told you. But fundamental rights does not only have Article 22, it had multiple articles. So where do you think you'd cover all of those important provisions of Indian Constitution? Where would you cover other important subjects, be it economy, history, geography? You'll have to study all of them, right? So you can do so by taking admissions in one of our courses. Now, these P2F foundation courses, as the name suggests, they cover everything from prelims to mains to interview. So everything that you need from GS till CSAT, you can cover everything in our batches, provided you take admission either in 2027 or in 2028. Now, if you're confused about which batch to take, let me clear your confusion. Students who are looking to give exams in 2027, you should take the 2027 batch, and likewise for 2028 students, right? And before you make the payment, please keep one thing in mind, that if you use the code ATS Live, it will help you fetch maximum discounts on all the courses, 2027 course, 2028 course, both of them, including the optional courses, you'll get maximum discounts if you apply this code. Okay, if you need any help, there is a number flashing on the bottom half of your screen. Do give us a call and give them my reference. Now let us try to solve this question. According to the Constitution of India, the central government has the duty to protect states from internal disturbances. Yes, this is correct, and it is given in Article 355 of the Indian Constitution. Now, the Constitution of India exempts the states from providing legal counsel to a person who has been held under preventive detention. So, I told you, under the first part of Article 22, you are to provide legal counsel to a person who has been arrested if they are unable to do so themselves. But those are applicable for ordinary cases. I told you those are not applicable for preventive detention. So, second statement also is correct. Now looking at third statement, according to Prevention of Terrorism Act, POTA, confessions of the accused before the police cannot be used as an evidence. Now this is true with normal cases or with normal laws. But Prevention of Terrorism Act was a special law enacted by Indian Parliament, and it provided for something, or it give state extra edge over criminals, right? So under this POTA Act, if a accused makes statement in front of a police, especially if the officer in front of which this statement or confession is made is above the rank of DSP, then it can be used as an evidence in the court of law, but only under POTA, not under criminal cases, normal criminal cases. So third statement is right. And we have to say third statement would be incorrect, right? Because the statement says it cannot be used as an evidence, but reality is it can be used as an evidence. And we have to identify correct statements. So only two, 1 and 2 is right. Third is incorrect. So the correct answer is option B. Now, before ending our today's discussion, I have a practice question that I've curated exactly on our today's discussion. So please do let me know the correct answer of this practice question in the comment section. I'll get out of your way so that you can screenshot it. Do let me know the correct answers in the comment section. And what do you think about this preventive detention? Do you think India as a democracy should continue with this provision of preventive detention, or it is actually necessary, or is it actually necessary for maintenance of our national security to have provisions like preventive detention? Do let me know what you feel about this issue in the comment section. I'll take your permission. Before going, if you want to download the notes, this is where it will be available. And if you have troubles finding the Telegram channel ATS Live, you can always scan this QR code. Okay? So I'll take your permission. Please have a very good night.